Good morning and welcome back. Happy New Year to you all. And thank you so much for joining us in our today's meeting. First of all, can I remind you all that we'll be recording our session today, and you can view it from our Facebook page and YouTube page as well. Thank you so much once again. As usual, my name is Mr. Usman Gay, the Community Development Worker, Family Voice, Peterborough. I'm here with my colleague, Judita, the parent rep. So as we normally do in our today's meeting, we will be discussing about appointeeship, deputyship, power of attorney. So we have two wonderful speakers here. I don't know who is going to start first. I will leave it with them. We got Kim, state planning. Yeah. We got Kim, state planning consultant, and Nick, managing director for will and probate services.
Good morning.
Good morning to you all. Yeah, and after the session or presentation, the floor will be open to you, all of you. If you want to ask any question, you are more than welcome to ask your questions. So after that, my colleague Judita will be doing the closing remark. Yeah. So Nick and Kim, over to you, please.
Okay. If I start, I'm Nick Ash. I'm the managing director of Will and Probate Services, as Usman just said. We are a firm based out in Market Deeping. We a specialist estate planning firm, and we have a particular speciality in families with children with disabilities and special needs. The presentation you're going to see today is a presentation that we've delivered numerous times over the past few years. It's always been well received and always is a presentation that prompts conversation, and that's what we would encourage you to do. As I say, my background is estate planning, wills and probate, which I've been doing for 16 years. Kim, her background is very similar. She works with me very closely as one of our estate planning consultants. And Kim also, additionally to her estate planning skills, has worked extensively with citizens advice and is quite good with the benefit system and things like that. You know, certainly when it comes to appointeeship and benefits, you know, Kim's your lady. But you know, we're here to answer questions as well as deliver a presentation. You know, we don't want it to be all jaw, we want it to be interactive if it can be. So, you know, feel free at any point to ask whatever questions you wish.
Thank you.
To ask.
Thank you, Nick. Yes.
Kim, do you want to say hello?
Yes, sorry. Yeah, hi. Yeah, I'm Kim. As Nick just explained, I've worked with Nick. I'm kind of the person that you'll potentially see face to face if you decide to, you know, have a further chat with us, or I can contact you after the meeting. At some point today, I'll put my contact details in the chat so that you know how to contact us should you need to. As Nick said, I've worked with citizens advice, helping people with benefits, claims and that sort of thing, appointeeship. I'm also a mum, so I have children as well. So it's obviously something that I understand. So I think, have you got the presentation there, Judith?
Ramu, yeah, we have to
Yeah.
ask our IT Ramu. She should be prepared. Ramu.
Okay. Sorry. It's just saying to me that PowerPoint is not responding on my screen, so I'm just trying to reload it.
Yeah, thank you.
If it's just our presentation, on the PowerPoint. If you give me permission to share screen, I have it here, so I could do it from here.
Yeah, I was just thinking the same actually.
Yeah, Ramu, are you okay for Nick to do it from
Yeah,
there?
fine, absolutely, yeah.
Yeah, Nick, you can go ahead then, please.
Okay. So can everybody see
Yeah.
that now?
Yeah.
Yes.
Yes.
Okay, so we call our presentation the 3 questions, and we address sort of 3 questions that every parent with a disabled or special needs child should be able to answer. And you know, as well as posing the questions, we try and give you some answers. And you know, you won't be surprised to know that those answers revolve around the things that we do, but we try and give you sort of practical answers, as well as, you know, this is not about selling you stuff. This is about advising you as a parent of a child with special needs or disabilities as to what you should do. And you know, the first key question is, who would look after my child if I died? There are many sort of estate planners out there who will tell you scare stories that if you die, your child will be instantly taken into care, which is not normally the case. But obviously most parents, they want to know that the person that they choose, the person that they trust, is the right person to look after their child in the event that they die, and to make sure that that appointment has some sort of legal force. Now, you know, the sad fact is that a child with disabilities and special needs is something like 7 times more likely to be taken into care if their parent dies than a child who doesn't have those needs. But all of the people that we talk to, or the vast majority of the people we talk to, they instinctively know who is the most suitable person to look after their child if they weren't around, but they don't know how to be sure and how to keep control of the situation. And also, you know, you will have a routine, you will have specific wishes, specific things that have to be done with a child with special needs or disabilities. That's not necessarily always the case with a child who doesn't have those needs. So the answer to question 1 is simply to make a will. You know, we know statistically that 2/3 of people don't have an up-to-date valid will, and we also know that half of all people who die without a will, and most people think it will never happen to them, and we find this is prevalent amongst the community of parents with children with special needs and disabilities, that you're so busy dealing with the day-to-day, you know, and you're so focused on what's directly in front of you, it's easier to think it will never happen. But if you make a will, you can legally appoint a testamentary guardian, and that appointment takes immediate effect. So if you die and there's nobody around who's got parental responsibility over your child, then you appoint somebody in your will that has legal effect, legal and immediate effect. If you die without leaving a will and there's nobody with parental responsibility still around, effectively the child will become a ward of court, and social services will get involved. And what they do from a practical perspective is they will immediately seek a temporary residency order to find somebody who can look after the child in the short term. And then they'll spend the next 6 months, 8 months going through the family with a fairly fine-tooth comb trying to find somebody who can take the child on a permanent basis, and then that temporary residency order will then fall away and a permanent residency order will be put in place. All of that can be avoided just by having a clause in a will that appoints somebody to be a testamentary guardian. So, you know, that's kind of, I know it's not, we're not on appointeeship and those sort of things, but we want to talk about if you die, what happens, and this is the single most important reason to make a will. You know, there's no argument with it. This is the single most important reason to make a will. Now, you know, normally when we're doing this face to face, we ask for a show of hands, and people put their hand up to show that they have or haven't made a will. But that 2/3 statistic stands up all the time. You know, whatever room we're in, that 2/3 statistic will stand up. So the second question, again, is to do with if you die, and it's about what happens to your money. So if you've got bad planning or no planning, you can really adversely affect any care package that a child is in receipt of. You can remove means tested benefits because the child suddenly got a big chunk of money that is theirs. Your child can lose the continuity of care because the package that's being delivered is not necessarily the package that they would get under a private arrangement. But the worst issue is when the money runs out, they'll be reassessed for their care needs under the prevailing regime. So effectively, if you die and you leave your child with disabilities or special needs a pot of money, you're kind of leaving that money to the local authority to spend as they see fit for the child. When the money runs out, they'll be reassessed for care under whatever the prevailing regime at the time is. And you know, we've been dealing with this sort of stuff for the past 16 years, and we have seen consistently that the level of care that is provided by local authorities or by the government through means testing has gone down and down and down and down. So you know, you lose your benefits package today. When the money runs out and you're reassessed tomorrow or sometime in the future. The general trend is that the package you'll get in the future will be worse. As I say, the inheritance is lost because that money just goes to the local authority over time and everybody loses out. So again, the answer to question 2 is set up a family trust. Now, the family trust can be set up during lifetime, or most commonly it's set up in the will of the parent. And basically, it allows assets to be left for the benefit of a disabled child, but not owned by them. So it's managed for them by trustees, and the trustees who will manage that are again your choice. The assets are out of the reach of social services and local authorities for the purposes of funding care packages. So that means that the care package that's in place is secure. The money can then be used to enhance whatever the care package is. So for the nicer things in life rather than for the day-to-day. So it can be used to provide holidays, it can be used to provide specialist equipment for the child, it can be used to just make their life better. And ultimately, if there is money left over, and you know, sadly, children with disabilities tend to have a shorter life expectancy than children without those needs. You know, if there's money left over at the end, you as the person building the trust can you can decide who that money goes to. So it can go to the charity that was supporting your child. It can go to other family members on the child's death. And that way, again, it keeps it out of the hands of social services and local authorities. As I said, most people set that up as a trust in their will. So as the parent dies, a proportion of the estate goes into a trust for the child with special needs or disabilities. But you don't have to do that. And we see quite a lot of times, care packages can be really badly affected by a grandparent thinking they're doing the right thing and leaving a few £1,000s to a child on their death. So if a grandparent leaves, say, £10,000 to a child, that can push them into the place where they are actually dealing with the means tested benefits not being available anymore. So it can be a completely unintended consequence of somebody, a grandparent, an uncle or aunt, thinking they're doing the right thing, moving money into the child's ownership and messing up their care package. Whereas if a family has set up a trust for that child during their lifetime, grandparents can fund that, parents can fund it, anybody from around the family can fund it, and ultimately, as their child trust fund, a lot of people have child trust funds, which are coming to the point where they're maturing now. The child trust fund could be placed into the family trust at that point as well, because I know there are a lot of issues in the community where people are not able to access family child trust funds as the child turns 18, and we'll talk about that a little bit more later. But the first two aspects of the presentation, I know they're not strictly on today's agenda, but they both boil down to having control of who looks after your child and having control of the money that you leave behind at the point where you die, is done by making a valid will that deals with those issues. And certainly that's something that I can advise on. It's definitely something that Kim, as the liaison point, she can talk to you about and advise on, the specifics of your circumstances.
Yeah, just to add to that, Nick, it's quite a low figure actually. Anything over £6,000 in savings will start affecting benefits. So if you're thinking it's like quite a big sum before it affects it, it's not. It's anything above 6,000 will start to impact on it. So.
Yeah. And that example I gave of a grandparent giving £10,000 is really not unusual, and unless that grandparent sort of discloses to the person who's making their will that the child has special needs or disabilities, it's unlikely to get picked up, and therefore the child inherits it absolutely, and it becomes a problem. So moving on now really to the meat. Sorry, we'll just briefly talk about the lifetime trust or will trust. I think I've already covered that, the additional benefits of the lifetime trust. The money can be passed into the trust at any time. It allows for inheritance tax planning if you've got a wealthy family. It means that other relatives can pass money into the trust. Parents will be the trustees of the fund while they're alive. It just is slightly more expensive to set up. The will trust is only set up on the death of the parent, so it's in the will and it's kind of set up when the parents die, so it is less flexible. Sorry, I should have covered that. So the key things that we really wanted to talk to you about were the issues that arise when your child turns 18. And the fact is, under British law, on the 18th birthday of your child, your parental responsibility ends. The law treats the child as an adult from their 18th birthday, and there are no exceptions to that. You know, it is a black and white thing. So effectively, your authority to make decisions for your child ends on their 18th birthday. Social services will then transition from the children's social care team to the adult social care team, which in itself is troublesome a lot of the time. You know, you are moving between two completely different systems that are not, you know, in our experience, are not brilliant at talking to each other. If you're lucky, the adult social care person will kind of involve you as a parent in that process, but they don't have to. You know, there is no legal requirement for them to involve a parent in that process, because they are, in their eyes, dealing with an adult. Now, you know, some people get a good transition, some people get a terrible transition, and it is the luck of the draw. And you can get to the point where decisions are being made for your child, and at the end of the day, they're always going to be your children, whether they're 18, 25, 30 or 45. You know, they're still going to be your children in your eyes. But from their 18th birthday, you know, the adult social care team can, and often are, making decisions without your input into the process, and you lose control. You know, for the first 18 years of the child's life, you have had pretty much the say over what happens, what care they receive, who's delivering that care, where that care is being delivered, if you're paying for it, how that care is being paid for. All of that falls away. All of that falls away. And, you know, you are at best an interested party who the local authority will consult from time to time if they see fit. At worst, you are ignored. And, you know, I've spoken to many clients over the years who have said that on their 18th birthday, everything moves away and they have felt ignored, and their wishes, their opinions, their knowledge of the child is not taken into account when decisions are made. So what we've got to do is we've got to avoid that if we can. And how we avoid that depends on the exact circumstances of the child, and some of it is financial, some of it is to do with the child's health and well-being. So the answer is to become their appointee. In some circumstances, it's about becoming an attorney under a lasting power of attorney. And in some circumstances, it's about applying to the Court of Protection to become a deputy. There are a couple of easy options and one more difficult option. And the appointeeship is purely a financial decision. And it is you as a parent making an application to the Department for Work and Pensions to deal with the benefits payments on behalf of the disabled person. Don't forget, they're a disabled adult now, they're not a disabled child. So you are acting as their appointee. It does allow you a limited authority to speak with adult social care on behalf of the person, because you are in control of their benefits. So they need to talk to you about how those benefits are used and how the money is spent. But it doesn't give you say over their health and welfare or anything like that. The good news is there's no cost involved, but it is the most limited of the appointments. Kim, do you want to sort of talk about how you actually apply for that?
Yeah, it's not difficult at all, actually. You go onto the department, the DWP's website. If you do a search under appointeeship, or if anybody wants me to send you the link, I'm happy to do that if you want to put your email in the comments. And then you just state under there which bit list the benefits. So you just state under there which benefit you want to apply for appointeeship under, and just fill in the application form. doesn't have to be a relative. It can be a close friend to the person. So you're applying for appointeeship. So then they assess it. They'll probably have a conversation with you, find out in a bit more detail why they're applying, and then decide whether they actually give you the appointeeship or not. And also, if it takes place, the money is then generally paid to you directly to spend on behalf of the person. So you actually receive the benefits on their behalf as well. So you do have good control over the financial side of things.
But you don't have control over the care, do you?
Not at all. No, purely a financial. It's really just the benefit. It comes to you to make sure that that's spent on behalf of the person it relates to.
Yeah, and quite often, if the person's only finances are the PIP that they're receiving, then the appointeeship is really very, very useful. The next level is the power of attorney. So the lasting power of attorney is something that gives you full control over all health and welfare decisions and all property and financial decisions. Now, there are two powers of attorney. So health and welfare decisions are probably the most important, because you are deciding at that point, as the attorney for the person who has granted the power of attorney, you're deciding everything about their care, from where they live to who's delivering the care, what circumstances that care is delivered in, whether it's delivered in the home, in a daycare facility, in a long-term care facility, in sheltered accommodation. You have the decision-making process over all of those things, and ultimately, you can make end-of-life decisions under a health and welfare power of attorney as well, as the attorney. With the property and financial one, you really only need that if appointeeship is not sufficient. So, if an appointeeship is sufficient and you're just dealing with benefits, then that's fine. You just won't need the property and financial power of attorney. If the person has assets in their own name, then the property and financial lasting power of attorney becomes useful, because it will give you all of the things that an appointeeship gives you, but then it also gives you the ability to manage the other financial affairs of the person with the special needs. So it sounds great. We should all do that. The problem with it is the person with the disability or the special needs must have capacity to consent to granting the power. So you can't take power of attorney over somebody. The person has to give you power of attorney. So if the person doesn't have capacity to consent, then you can't get a power of attorney. If they do have the capacity to consent, then you can get a power of attorney. Now, the good news is that there is an assumption that a person has capacity in law. So it's the 2005 Mental Capacity Act, says that a person has capacity at all times, except for when it can be shown that they don't have capacity. And there are two tests. There's what's called a practical test, and there is a functional test. So the practical test for capacity is if somebody has an illness or a condition that is diagnosable by a doctor, and a doctor says this person doesn't have capacity, then it rebuts the presumption of capacity, and the person can't grant the power of attorney. However, there is the test that's more useful for us, and it especially applies with children with autism, for instance, where they may not have full capacity, but they have certain levels of capacity. And certainly, when we're dealing with clients in the more elderly range, it applies for people with dementia, for instance. And it's The functional test is a test that's applied by the practitioner. So somebody like myself or Kim, when speaking to the person with special needs, is making an assessment, and we're bound by the Act to sort of weigh whether they understand the information that's pertinent to the decision. So whether they understand that they are granting somebody else a power to act over their health and welfare decisions, whether they're able to retain and use that information to weigh up the consequences of making that decision, and then ultimately whether they understand the consequences of making that decision. Now, as long as we are happy that those three things are present, even with a person with quite severe disabilities, you know, they are quite often able to consent to granting the power of attorney. You know, we can get around communication difficulties, we can get around language difficulties. I mean, I recently did one for somebody who was both deaf and mute, but we were able to do it by writing the questions out, them reading the questions, and them indicating their consent on like they had an alphabet board, and they were able to indicate their consent by using the alphabet board and spelling out the answers. So you know, we do have ways of getting the power of attorney into place, even when it looks quite difficult to do so. Yeah, and part of the Mental Capacity Act says a person cannot be assumed to lack capacity until all possible steps have been taken to help them to make the decision. So we are used to helping people make a decision and taking as many steps as we can to get there. If you can get a lasting power of attorney in place, it overrides the local authority decision-making powers. It keeps the decision-making powers within the family, and the attorneys, and we always try and appoint more than one attorney. You can appoint between 1 and 4 people. We always try to appoint more than one. Attorneys have the ultimate say in any decisions. So in most circumstances, we're appointing a parent, and we're perhaps appointing a sibling, or appointing both parents and a sibling if we can, so that if, you know, ultimately, because this is in place for life, if the parent dies before the person with the special needs, then there needs to be somebody else to sort of step up and start making those decisions. It's relatively inexpensive to put a lasting power of attorney in place, and it's available from the child's 18th birthday onwards. So you can't put a lasting power of attorney in place before the 18th birthday of the child. But you know, if you have your application ready to go, it can go in on their 18th birthday, and it will be in place relatively quickly after that. I mean, currently the Office of the Public Guardian, which is the government department that's responsible for registering powers of attorneys, they're taking around about 14 to 16 weeks to register a power of attorney. So within 4 months of your child's 18th birthday, you can be back fully in control of their affairs, if it's possible to put a lasting power of attorney in place. These powers do have to be registered with the Office of Public Guardian before they can be used, and the Office of the Public Guardian has oversight of the powers, and you know, their remit is to make sure that the powers are not abused and not used for anything that's not in the best interest of the person who has granted the power of attorney. So that's lasting powers of attorney. But obviously sometimes it's not possible to get a lasting power of attorney in place because the person lacks capacity. So the ultimate thing that you have to do is you need to make an application to the Court of Protection to be appointed as the person's deputy. And again, it's similar to the lasting power of attorney. There are 2 deputyships that you can apply for. The first is a financial one. it mirrors exactly what the power of attorney does. It gives you control over that person's finances and their property if they own property. And then the second one is personal welfare, and that gives you control over the health and welfare. Again, mirroring exactly what the power of attorney for health and welfare does, but this is the court giving you permission. So I said when I was talking about powers of attorney, the disabled person or the person with special needs has to grant you that power. With a deputyship order, it's not the person who's granting you that power, it is the court that is granting you that power. So you are applying to the court to become the person's deputy. And the court views this as, you know, quite a serious decision. And they want a lot of information. So as a consequence of that, you are into a much longer process. So it takes between 6 and 9 months as against the 3 to 4 months. It is relatively expensive compared with the power of attorney, and there are ongoing costs because you have to pay for the ongoing support and supervision that you get from the courts. Yeah. So this is something that we apply for in extreme when the disabled or special needs person does not have capacity and cannot give consent themselves. Now, the good news about this is it's available from age 16 onwards, so you can start applying when your child turns 16, and you know, in most cases by their 18th birthday, you know, the application will have gone through and you will have the deputyship order in place. Again, it's similar to a power of attorney in that you can have more than one deputy. So you can have, again, a parent and a sibling, or 2 parents as joint deputies. The courts are generally quite amenable to giving the financial deputyship. So the financial deputyship is relatively straightforward to get. However, there is a presumption in the courts that giving the health and welfare deputyship as carte blanche over that person's health and welfare is not something that the court are generally pre-proposed to do. They tend to prefer making decisions on health and welfare on a as and when basis. So as and when a decision needs to be made, they prefer the deputy to, or the person who wants to be the deputy, to make an application to the court for a decision. Now, it used to be that they were almost impossible to get. Nowadays, they are a little bit easier to get because local authorities are being quite cooperative with this, and they are actually saying to the courts that it helps them if there is a deputy in place for health and welfare, because it gives them certainty over the decision-making process. So in many cases, the local authority are the people asking the parents to make a deputyship application on behalf of the person with special needs or disabilities, and the local authority are assisting and helping with that application. So they're giving information about the person's capacity and their abilities, and they're giving you information to the courts about why they think it is a good idea for the parent or the sibling or whoever to be appointed as a deputy. But you know, we can't ever start from the assumption that if we make a deputyship application, it will be granted, because in many cases, the health and welfare side of it won't be granted. The courts, when they do grant a deputyship order, they do look at ongoing supervision, and the ongoing supervision really depends on the amount of assets under management, and if they're relatively small, there's fairly light touch supervision. If there are significant assets under management, then you know the supervision requirements are quite onerous. in any case, you have to, no matter what you're doing, you have to submit a report to the court each year, and you have to submit accounts to the court each year showing what actions you have taken as the deputy for the person that you are deputy for. So, there is work to be done with the lasting power of attorney. There's no reporting requirements. Once you're an attorney under a lasting power of attorney, that's it until somebody basically sort of makes the Office of the Public Guardian aware that there's any issues. Whereas with the Deputyship Order, you are constantly under the supervision of the courts. So those are kind of the options. As I said, it's kind of about keeping hold of the control of your child's lifetime. It can also keep control and choice in the hands of the family beyond your own lifetime, if you've got a sibling or somebody in case. And it's about being in the hands of those that you trust to make the best choices for your child. We appreciate they'll always be your child, even if in the eyes of the law they're an adult. So the costs, these are our costs. Obviously, there are lots and lots of different people that will help you with this, but I just thought I would share our costs with you. So if you're making a single will with a disabled or special needs trust, it's 329. Mirror will, so that's if you're a married couple and you're making wills that mirror each other's intentions with the appropriate trusts in place, that's 599. If you're doing the lifetime trust and putting that in place during your lifetime, as I said earlier, it is a little bit more expensive, so it's 1,098 for a single, or for a couple it's 1,228. The single lasting power of attorney is £250. The two lasting powers of attorney together are 400. You have to then pay a court fee of £82 per document. For us to help you to apply for a deputyship order, it's £849 plus your court fees. Then you have to put an insurance bond in place, and then you have to pay supervision fees. So typically the total cost of an application is £2,500, and then the ongoing costs of the deputyship order and the reporting, the supervision fees and the reporting requirements tend to work out at about £500 annually. So as you can see, getting a deputyship order in place is about 10 times the cost of getting a lasting power of attorney in place, which is why it's always advantageous to get a lasting power of attorney in place if you possibly can. As we said, if it's just an appointeeship, you can do that yourself. You can apply online and do that yourself, and there are no costs involved with that. Now, as ever, we are a commercial organisation, so it's in our interest to make an offer. So, if you want to book a no obligation consultation with us in the days following this, we will give you a 20% discount on our fees for anything that we do. Obviously, that doesn't include any court fees or third-party fees. That's purely the fees that we would charge. If you want to do something, you can either get in touch with Kim, or you can book a consultation. So, I mean, that's it as far as the presentation's concerned. So I'll stop sharing the screen now. But obviously, we're here to answer any questions that you may have. So if you've got any specific questions and there's anything we can help you with, just feel free to ask, and either Kim or myself will be happy to answer anything.
I've also just put my email address in the comments on the Zoom as well, just in case anybody has any questions that they may not feel comfortable asking live at the moment. They can always contact us after as well.
Yep, I've got a question I wanted to ask.
Fire away.
Right. From what I understand from your presentation, currently I have got appointeeship for my 16-year-old. She's just turned 16 in December. I called actually to inquire, but I did become aware that only one person can become an appointeeship at any one time.
That's correct.
So you just saying about the power of attorney, is that so with the power of attorney, you can have more than one person? Because I was getting quite worried that what if something happens to me?
Yeah, so with the power of attorney, you can have up to 4 people who are appointed.
Wow.
So, you know, you can have yourself, a spouse or a partner, or you could have, you know, a sibling or a friend of the disabled person. So, yeah.
You can have a reserve set up on the power of attorney as well, can't
Yeah.
you, Nick? So
Okay, so the last thing, I know you spoke about the 2 types of powers of attorneys, the power of attorney and the lasting power of attorney. Is that correct, or am I wrong?
So they're both called lasting power of attorney. One's called a lasting power of attorney for property and financial affairs, and the other is called a lasting power of attorney for health and welfare.
Right. Okay then. So I saw you had 2 prices on there. One says buy 1, one says buy 2. What?
Yeah. So if you just need the health and welfare one, so if for instance you know your appointeeship is dealing with the benefits, there are no other assets, and you're happy with your appointeeship, but you need the lasting power of attorney to deal with the health and welfare issue,
Okay.
then you would just apply for one. If you felt that you needed both because you need to broaden out that appointeeship, as you just identified, and you also need the health and welfare one, you know, we give a discount for buying both, essentially.
Okay. So with the lasting power of attorney, it
Yeah.
does not come to an end until obviously a request has been put in, or?
So the lasting power of attorney is once and done. It lasts for the entire lifetime of the person. You know, as long as there's still an attorney alive, then the document is still valid. So
Okay then. Okay, that's fine. So from what I understand, the deputyship can only come into place due to lack of consent. Is that correct?
So the deputyship comes into place when the court grant the application, and yeah, if the person has no capacity to consent,
Yeah.
then you have to apply for the deputyship. If
Okay.
if the person has capacity to consent, in most cases it's possible to get a lasting power of attorney in place.
Okay, that's brilliant, because I was getting quite confused with all 4 of them. Okay, that's brilliant. Thank you.
Is there anybody else?
Hi, Nick. Yeah, just a quick question, just to sort of clarify. I think you maybe covered this, but so the appointeeship and lasting power of attorney both have the situation where the person with special needs has to grant the permission for that. Is that the case?
No, you don't have to get permission with an appointeeship. So
okay, yeah.
you can just apply for an appointeeship and get that granted.
Right.
You know, the question of the ability to consent is around lasting power of attorney.
Right, I see.
Yeah.
So, and the appointeeship, that was primarily to do with finances, wasn't it? Is that correct?
Yeah. So effectively, it allows you to take control of their benefits.
Yeah.
So yeah,
just their benefits. Yeah.
Just their benefits. So if they've got a bank account or a child trust fund or something like that, it doesn't deal with any of that.
Okay.
It is just dealing with the DWP for PIP or whatever other benefits that they may be received of.
Right, I see.
But it does give you a little bit of power, because it means the local authority have to talk to you because you're actually getting the money. So they have to talk to you about, you know, how that money's going to be spent, type of thing. But
okay.
It doesn't give you any formal decision-making power.
No.
However, the lasting power of attorney or the deputyship order does give you that decision-making power.
Okay, thank you.
Yeah, I'm just gonna come back again. With regards to the apprenticeship, I just wanted to ask a question. I'm not sure if I'm not asking at the right platform. In relation to PIP, if the individual has been called in for an assessment, due to like me having apprenticeship, can I act on their behalf or not? Because obviously I know she hasn't got the mental capacity to do so herself.
Kim?
Is the assessment being done face to face or over the phone? Has it been decided?
It's not been decided yet, but I was just wondering because from the notes I was reading, it said about you might be called in for an assessment or it might be a face-to-face one. So I just don't know how to prepare myself.
Yeah, it's going to be with the person with special needs really that they'll be needing to sort of speak with. I mean, but do they have issues talking on the phone? Would that make that difficult for you?
Yeah,
they do. I would imagine ultimately what they'll probably do then is arrange to come and see face to face, because it is the person that's getting the benefits that they will need to assess. So if they aren't able to communicate on the phone very well, I would imagine that will be, this decision will be made on that basis and it'll be arranged as a face to face appointment.
What if the individual has not got the capacity, like even face to face, they cannot hold a communication with?
No, because they're more assessing obviously their physical ability in the PIP assessment. So
not more so the mental as well.
Yeah. No, I mean obviously they'll be looking at what capacity they have to communicate and everything else, but that's kind of part and parcel of the whole assessment. So it's not so much, the capacity isn't so much as a driver with the PIP, if that makes sense.
Right. Okay then. Okay. Yeah. Okay.
Okay. So yeah, I would speak to, obviously just speak to the benefits department. You've obviously had the letter through for the assessment and just getting you get in contact with them and then try and arrange it that way. But I would imagine they'll agree to go face to face, which kind of alleviates the telephone issue. So
okay then. Yeah. Oh, thank you.
Any other questions at all we can help with? Oops, I was a bit late. Let's reconnecting.
Any more questions, please? Seems like everybody's happy about the presentation.
We've got someone just joining, haven't we? Connecting by audio, but they haven't arrived yet, so it's a bit unusual.
If you have any question, please come forward as well, please. Yeah. Because this is really very, very important topics for all of you anyway. So yeah, if you need any question, any clarification, please you need to come forward and ask because we still got time anyway. So yeah.
I suppose one question that does just spring to mind is obviously, at the moment in our situation, we're looking some years into the future in terms of needing to put this in place. Yeah. There's always this crystal ball factor, isn't there, in terms of government policy and all this kind of thing, and tax laws and all the rest of it that change over a period of time. But are the sort of principles of appointeeship, lasting power of attorney, and deputyship, are they sort of almost above government level, or are they likely to change?
Gosh, what a question. So
get your crystal ball out.
Okay, so the bit we did at the start around wills, that's not in the future, by the way. You should do that now. You should do that today. That hasn't changed since 1837, so that's pretty much set. So we're kind of quite comfortable with that. The rules for lasting power of attorney have been in place since 2007. Prior to that, it was something called enduring power of attorney, which was different. So we're quite comfortable that they've been around for a long time and they're unlikely to change. The one that's in flux is the one that's always in flux, which is the benefits question. And benefits is absolutely in the hands of the government policy. So the wills, the court of protection, and the lasting powers of attorney are kind of, like you say, they're not entirely beyond government control, but they are set and they're pretty much working well and unlikely likely to change.
Mm.
But certainly when you talk about appointeeship benefits, PIP, anything like that, that is government policy 100% and can
Okay.
change at any time and does frequently.
Okay, thank you.
Any more questions?
So I would, from what I've gathered today, looking at it at the moment, the most secure, I would say, personally for me, is probably the lasting power of attorney. Because I think with that one, at least you've got backup if anything happens.
Yeah, you certainly have, yeah.
That it just isn't one individual having to deal with the affairs, that if that person suddenly dies or whatever, there's still backup with somebody else who can take over.
Yeah, absolutely.
Okay. Yep. Thanks.
I mean, I would just reiterate what Kim said. She's just put her email address in the chat. If you don't feel comfortable asking questions in an open forum, or if you've got something that's very specific to your circumstances, just drop Kim a line, and she will, answer those individual queries and sort of be able to give you more sort of personalized, tailored advice if you need it. So, and what we always say is, it doesn't cost anything to talk to us. We will advise you initially free of charge. It's only when you decide to take action and we're producing the legal documents for you, that's only when the costs kick in. So, talking is free, and we're happy to talk to anybody.
Yeah, if we can answer any questions that you might have, it's always, it's nice to be able to do that. So without, we don't do an hourly rate or anything like that, do we, Nick? So
no,
all good.
Fantastic. Are you all happy for us to share your presentation with the other community leaders? Because there are a lot of people who wanted to join the meeting, but due to a lack of time, so they couldn't, So is there any possibility that we can
you could share it with whoever you wish.
I can see your contact number and everything is there. If anybody want to get in touch with you, then they'll be more than happy to get in touch with you. Yeah.
Yeah.
Okay.
Yeah, happy to do that, and happy to sort of rerun the presentation for you if you sort of feel there's an audience that needs it. We can do it.
Yeah.
And as I say, one day when this whole pandemic ends, we'll even stand in a room and do it and talk to people live.
A bit more sociable, isn't it? Live and talking to people.
I'm
nicer.
sure we will need you again anyway. So in due course anyway. So yeah.
Yes, of course.
We always run these kind of meetings, and we realize that these are very, very, very important. Honestly, I wish we could have everybody attended today, but unfortunately, most of them they couldn't make it. But definitely, we are hoping in next coming months, a lot of them will be able to attend another meeting session.
Yeah, well, it bears repetition. We're happy to do it.
Yeah, brilliant. Thank you so much. Thank you so much. Judith, over to you, please.
Oh, I'd like to say a huge thank you to each one of you for your time today attending this meeting, and a big thank you to our brilliant speakers, Nick and Kim, for their great and very informative presentation and their answers. A big thanks to our participants, guests, to our parent carriers, and for the team of the Paynels Peterborough also. I would kindly ask you to please complete the session's feedback form after the event. Giving feedback to us is very vital in helping us to be able to secure funding to run more of these sessions. The feedback link is already sent to your emails. Our next meeting is 22nd of February, the same time, 11 a.m. 12:30, and the topic will be find out what special educational needs, support and education, health and care plan are. Find out about the graduate response to special educational needs and disability. Peterborough City Council officers will be speaking on that topic. So looking forward to seeing you all at our next meeting on February 22nd. And once more again, thank you very much to everyone for today. Thank you.